We heard this morning about projects and proposals from the European Commission. This afternoon, I will talk more about existing legislation and touch on future developments only very shortly, because it is quite interesting to see what and how European environmental law is treated in practice. This is the Dieselgate story, of which many of you might have heard in the newspapers and the media. Most of you, one way or the other, via families and so on, own a car, and one way or the other are affected by these aspects also. This Dieselgate started in the United States. And I will come back on the question why in the United States, where we deal with European car producers and European legislation. In the United States, there are bodies, Environment Protection Agency at federal level and the Canadian Air Resources Board, the CARB, who deal with the protection of the environment from products, from activities. We do not have such a body in Europe, neither at European level nor at the level of member states. And so it might not be an accident that this Dieselgate started to be discovered in the United States. I will not read all this history of this scandal in detail. You have it on the screen and in your folder. What is relevant is that in September 2015, Volkswagen company, this German multinational company, admitted before the United States authorities that it had manipulated about 11 million cars worldwide in the simple way that they installed in these cars a so-called defeat device. This is a software instrument which was capable of discovering when the car was tested in a laboratory. Because the wheels didn't move, the steer didn't move, and a number of other items. And in this case, there was an additive added to the diesel which in the car, which dissolved the nitrogen oxides from the diesel car. When the car was on the road, this additive only was added in specific situations, when there was a steep hill or a sharp corner or something of that kind. But normally, during the road use of the car, the additive was not used. The result of this manipulation was that the nitrogen oxide emissions from the cars were up to 40 times higher than legally permitted. This was a manipulation which Volkswagen had started in 2009 and practiced, as I said, for about 11 million cars worldwide for in the meantime, it's 7 years. The software was supplied to Volkswagen by the Bosch company from Germany, which had warned Volkswagen that the installation of the software was illegal, but continued to deliver the software for 11 million cars, which has the consequence that in the United States, at least, Bosch company is investigated also whether it would not, it had not contributed to this manipulation. The Volkswagen had a number of negotiations in the United States, and overall, until now, March 2017, paid in the United States $22 billion in compensation for criminal sanctions, for administrative sanctions, and for civil law sanctions, which is quite a remarkable sum. Volkswagen also paid $1.5 billion Canadian dollars to Canada authorities and paid some compensation to South Korea. In other countries, and in particular in European Union countries, there is not yet any final judgment which was made against Volkswagen. The Italian authorities charged Volkswagen with some administrative fee. If I remember well, it was some 50,000 euros. The European car users who have had manipulated cars had to go to court individually or collectively charge an attorney. And these cases are going on in the different countries. In Germany, there are about 200 cases which have been brought to the courts and decided by the courts. 80%, some 160 thus, went in favor of Volkswagen. 40 of them went in favor of the car buyers who asked for compensation for returning the car or other ways. No final judgment from any Supreme Court has existed until now. And of course, there is a strategy from the company also when the court judgment is unfavorable to go for some sort of voluntary compensation in order to get off the hook from a final Supreme Court judgment. The situation thus is that neither in Germany, nor Italy, nor Spain, nor France, nor UK, or any smaller member states, is there any final judgment on the issue whether this was fraud, whether the purchase contract between the buyer and the trader, or the buyer and Volkswagen, as national law might lie, is illegal, whether there is some right of compensation for returning the car or any other way of handling the issue. Now, this is the manipulation which I talked of. German authorities made an investigation and examined some 60 cars from quite a number of car makers and found that practically all had some sort of mechanism inside the cars that the engine switch, the addition of the additive was switched off when the temperature was below a certain level. The normal thing was below 10 degrees, but Opel in Germany was below 17 degrees. That means in Western Europe or in Europe, in the European Union, we have temperatures which are below 10 degrees, at night in almost half of the year, and at daytime in many parts of the country for 3 months, 5 months, 6 months or so. The result of this manipulation was that the cars emitted nitrogen oxides more than they were allowed to, more than the legal requirements were stipulating. And the purchaser, the car user, didn't know of anything of that. This is the situation. Fiat, the Italian manufacturer, had a mechanism where the additive addition was switched off after 22 minutes, and this becomes comprehensible if one is aware that the test in the laboratory takes 20 minutes. So it is relatively clear, though it has not yet been officially confirmed yet, that this was a way of bypassing or overcoming the different test results in the different member countries. Now, let's look at the more legal side of these issues. When you have the product car, you want to bring a new model on the market in Europe, you have to construct a model, a so-called type, and you got to get a type approval of this model. Then once you get the approval of this type, you can construct the different cars, millions or thousands or whatever, according to this type. And for each of the different cars, which then the individual purchaser buys, you have to get a certificate of conformity from the car manufacturer who certifies that the individual car is conform to the model. This is the idea. As regards taxes and fees paid to the public authorities, in most of the countries they depend on the size of the car, on the engine. More recently we have on car emissions, CO2 emissions in particular. And then we have driving performance, I will come back to that, and sanctions. The type approval is regulated by the European Union. This legislation lays down in a very detailed way all individual requirements for the safety belts, for the lights, for the mirrors, for seats, for every imaginative thing that you might consider. The legislation also refers to air emissions from the cars. What is interesting for the legal side is that these tests for getting the type approval, it is the car manufacturer who is responsible for that. And either he makes himself in his own laboratories the tests for compliance with the legal requirements, or he charges the public body, the Germans might know the TÜV, Technischen Überwachungsverein, public body to make these, private body, sorry, to make these examinations. The type approval agency is installed in all member countries. This is a national agency, normally a public agency, and the income stems to a large extent from the fees which the manufacturer pays in order to get the type approval. The manufacturer, let's say of an Audi car, is free to decide whether he wants to go to a German type approval agency, to a British or a Slovakian or a Malta type approval agency. And this is under suspicion to create some sort of competition among the agencies. In other terms, the manufacturer chooses the agency which is the less stringent on testing the car. What is remarkable is that the type approval is valid all over the European Union. Thus, type approval given by Belgium makes the car applicable for the Italian market or for the Greek market also. The agencies do not make the type approval tests, so that compliance test whether the car complies with the legal requirements themselves. They rely on the data which the car manufacturer delivers. Now, there is a clause in this European legislation which states that if the systems, components or separate technical units have electronic controls, information concerning their performance must be supplied. And this means, in legal terms, probably, there is not yet any court judgment on that, that such software, which was, as it was used by Volkswagen, also needs to be communicated to the type approval agency. But until 2016, no car manufacturer gave data on the electronic systems to the type approval agencies, claiming that is confidential information, copyright and commercial secret, and so on. The car manufacturer promises by this certificate of conformity that the individual car in question conforms in all details to the prototype, and what is remarkable, there is no further testing of the individual car as to its conformity. It's the certificate of conformity which is decisive for arguing that the specific car is in compliance with EU legislation. As regards driving performance, all of you who have a car probably know that once every 2 years or once every year, that's different according to member states, they have to go to some sort of technical inspection to have examined the roadworthiness testing of the passenger cars. The program which is laid down in the European legislation is a minimum program. It fixes air emission testing. However, only a failure of this examination only exists when the carbon monoxide levels are exceeded. Carbon dioxide, the greenhouse gas, or NOx or the PM levels of cars are not, according to the directive, are not examined, and certainly are not considered to be a failure when they are when the levels are exceeded. The European system, as I said, was just on the laboratory testing. The scandal in the United States came to light because the agencies over there, the Environment Protection Agency and the CARB, the Californian agency, tested the cars also when they were in use, when they were used on the road. And there they found the difference between the legislative requirements and the test results for the conformity, for the type approval checking, and the reality, which was, as I said, 40 times difference. The Commission European Commission had some sort of suspicion in 2011 and asked this research center in Ispra to test cars, which they did, but and they communicated the results to the European Commission, but the Commission didn't do anything on that. They just kept these things in the drawer. The defeat device, which I had mentioned, I put on the screen the definition. It is in principle a very easy thing. Any mechanism which changes the results of the emissions is prohibited. It's as easy as that. But these defeat devices are prohibited under European law since 1999. I again repeat, since 1999, and member states were obliged since 1999 to put that into their national legislation. The member states, of course, had to communicate to the European Commission what they had done with this legislation, and until October 2015, when the scandal in states had been disclosed, the big countries had not communicated any information as regards these defeat devices. And the Commission had been silent on that too. The directive, the regulation from 2017 said the defeat device may be used when the need for the device is justified in terms of protecting the engine against damage or accident and for safe operations of the vehicle. And this is the clause which the car manufacturers used by saying, well, when the temperature is below 10 degrees, or below 17 degrees, we need to switch off or we need to activate the defeat device in order to protect the engine. I submit to you that this is pure legal green speak, because, as I said, temperature in Europe is normally frequently below 10 degrees, and the car shall be used in normal driving conditions. It is made for the European market. The type approval is given for the European market, and therefore arguing that the defeat device is necessary to protect the engine when the degree is below 10 degrees, the temperature is below 10 degrees, is just not an argument which can seriously be used. But it is used, and still today. As regards sanctions for the ban of defeat devices, or for not complying with that, member states decide whether what kind of sanctions shall be used. We have no system at European Union level for sanctions against breaches of European environmental law. The exceptions is the Emission Trading Directive and the CO2 emission directive for trucks and for passenger cars. The United States have a provision in their national legislation that the level of sanction depends on the gravity of the infringement, the economic benefit for the wrongdoer, the size of the business, the history of compliance, remedial action undertaken, and the capacity to pay. And this provision was used in order to charge Volkswagen with an overall thing, if I take all these things together, with $22 billion. We don't have a similar provision in any European or national legislation. Question, why were the sanctions taken in the United States against Volkswagen but not in Europe? Well, the answer is the prosecutors in Europe, in a number of different countries, France, Germany, Spain, with some hesitation I would also argue Italy, are still examining the case. And there's not anything known in detail about the defects or the results of this investigation. As I said, the driving performance does not measure the NOx emissions, the nitrogen oxide emissions, or the carbon dioxide emissions. Why not? Well, the environment has no lobby. There's nobody asking for that, and the car manufacturers managed to get it until today, this limited kind of examination. The Commission was asked to control whether that the Commission should examine during the years whether the emission limit values which were fixed in the type approval reflected the emissions generated by real driving on the road. This was a requirement for the Commission since 2007, and the Commission was obliged to make amendments to the legislation if necessary. The Commission didn't do anything between 2007 and 2016. In 2016, after this scandal had broken out, there was a new regulation that now cars are also tested on the road to see what kind of real emissions there are. Following the scandal, the Commission has made a proposal for a new regulation, which is for the moment pending in Council and Parliament. Practically, the system remains as it stood. There is a national type approval agency, and the cooperation between the national authorities should improve anymore. Perhaps I give you just an example of the intensity of the examination for the time being. Germany found that, the German authorities found that Fiat was suspected of switching off this additive addition after 22 minutes. So they asked Fiat to discuss the findings with them, and Fiat said, well, we have our type approval obtained in Italy, so we are not going to discuss with you, we are discussing with the Italian authorities. And the Italian authorities said, we didn't find any problem with Fiat, and that's where we stand for the moment with the Fiat situation. The new proposal from the Commission is that the Commission is entitled to test cars in the laboratory or on the road by itself. And if it finds inconsistencies, it may impose administrative fines up to 30,000 euro per car. Now, I told you earlier, and I'm aware that my time is running, I told you earlier that the Commission tested cars already in 2011 via its research center in Ispra. So this is nothing new. The Commission just didn't do it these years between 2007 and 2016. And so the only new element is that the Commission should be able to fix 30,000 euros per year. We will see what member states say to these things. I'm rather skeptical with regard to this one. Now, in order to overcome this new situation with real driving emissions testing, the car being tested on the road, there was a problem because the real emissions for the moment are much higher for practically all cars. So what did the European Union do? They adopted a regulation in 2016 by saying the NOx emissions, the nitrogen oxide emissions for diesel cars, were allowed to be 50% higher than fixed in the legislation, in the 2017 legislation. This was done by a so-called comitology decision, not by a Council and Parliament regulation, which in my opinion makes it already illegal because you cannot amend a regulation in order to justify it by technical and legal uncertainties. For a period of 4 years, the level of nitrogen oxide emissions was allowed to be 168 milligrams per kilometer, while the legal requirement, the Euro 6 standard, is 80 milligrams per kilometer. So it's 210%. For trucks, which practically all run on diesel, no NOx emission is fixed for the moment. So there isn't anything which limits the emissions from that. For carbon dioxide, the greenhouse gas emission, passenger cars have a limit of 130 grams per kilometer, but this is the average of the car fleet. This is not the individual car. And I put you here on, in brackets a bit, the actual figures published by the Commission for 2016. For 2016, BMW 197, Ferrari 299, Lada 216, McLaren 267, Mercedes 208, Ford 255, and so on. That means all these cars do not respect the CO2 emission limit value. Now, there is a trick in this regulation which says you need not limit the CO2 emission for the car fleet of Mercedes once Mercedes goes into a pool with another manufacturer which has lower emissions. You might know all the smart car from Mercedes, which is a very small car and which emits very low pollutants. Mercedes joins these two things, and with this mixture is managing to respect the 130 gram per kilometer value in legal terms. So the EU legislator is really trying to ease the life of the car manufacturers first by manipulating the 80 milligram per kilometer for nitrogen dioxides, and second for the carbon dioxides. This brings me to what European and national authorities omitted to do in this file. Legislation existed, but the Commission was charged to control the real driving of the cars and eventually make proposals for amendment. It didn't do so between 2007 and 2016. It didn't adopt or make proposals for real driving emission provisions prior to 2016. The defeat device was prohibited, and member states were asked to fix sanctions and to communicate them to the European Commission. They didn't do so, and the European Commission didn't take any action against member states. They only asked them about their legislation in 2015. It didn't review the directive on the car driving performance, and they didn't adopt this regulation on the real driving emissions until 2016. Member states did not request car manufacturers to submit the software which they used for this 10 degrees Celsius case when they asked for type approvals. They didn't check the existence of defeat devices. They didn't adopt legislation on the ban of defeat devices, in particular not the car manufacturing countries, France, Germany, Italy, Spain, United Kingdom. There was practically no way of cooperation with member states, and the market surveillance systems for existing cars on the market and their emissions was just defective. They trusted on the car manufacturers and didn't provide for effective, proportionate and sanctions. Now, this is the conclusion. With all these issues, we have the official figure of 430,000 premature deaths per year in the European Union. This is 10 times the figure which we have for car accidents in the European Union. 10 times, and nobody cares. The environment has no voice, and therefore this passes on in silence. The annual economic loss is estimated to be 23 billion euro. The environment has no voice, and nobody cares about these figures. I pass with these words the relay to my colleague Udo Tadei, who will talk to you about air quality issues. But first, let me thank you for your attention and see whether you have any questions or comments. Thank you.